It's not just that Lemon is a bad or a vague or a confusing test. It's that it just brings us so far from what the Establishment Clause means that I think like aggressive remedy is necessary here. There's a whole host of religious activity in the public square, publicly funded, publicly supported prayer at government functions, prayer in schools. Still, we're not even close to touching what the Establishment Clause was meant to prohibit, which was very particularly the government picking a religion, supporting it, funding it, punishing dissent from it. That's what an establishment is. That's the only thing that an establishment is. Putting up the 10 Commandments on a school wall, like, it's not just that Lemon is bad and Lemon could make this look like an establishment. It's not even close. Welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal.
And I'm Joseph Clement, Content and Program Manager at Napa Legal.
You're listening to the Napa Legal Weekly Podcast, where we explore religious liberty from the perspective of faith-based nonprofits. So this week we'll be covering several important cases. We'll start with a really big religious freedom case that the U.S. Supreme Court has agreed to hear next term. That's the St. Mary's case. Then we'll go to the Fifth Circuit and talk about the latest 10 Commandments case in a series of these cases that has been going on recently. And then we'll finish up with a quick treatment of a recently passed Tennessee law that creates a civil right of action for individuals who are harmed by doctors performing sex-rejecting procedures on them when they were minors. So a lot of big, important cases today. Let's start at the Supreme Court in the St. Mary's versus Roy case. So you may have heard of this. If you're listening to this, chances are you've already heard of it. There's a lot of buzz that was going on in the pre-cert stage. And now that the Supreme Court has agreed to grant cert and hear this case, we thought we would go through it in some depth. So this is, like many religious liberty cases, generated out of Colorado. There's a universal preschool program here that gives rise to the case. So the program gives parents the ability to send their children to preschool at no cost. Parents can rank up to 5 schools that they'd like to send their children to. If a school gets accepted into the program, the parents get a voucher and it pays the cost of tuition for the preschool. What is controversial and has led to this case is that in order for a school to be eligible to receive the vouchers, it must agree not to take in consideration a student's quote unquote gender identity when deciding to offer or withhold admission to the program. So several Catholic preschools, including St. Mary's, were denied access to the program because they do require students and families to abide by Catholic teaching on human sexuality, which comes in conflict with that gender identity law. So St. Mary's filed suit. The school argues that Colorado's denial of their school into the program violates the free exercise clause and contradicts Supreme Court precedent, particularly in the precedent set by Carson v. Macon, because it denies access to a public benefit, in this case, the preschool vouchers, solely based on religion. St. Mary's lost this case at the lower courts, including recently at the 10th Circuit, and now the Supreme Court has set up what we have now by agreeing to hear the case. So there's a lot going on here. There were 3 questions presented that were offered by the lawyers at Beckett representing St. Mary's. Only the first 2 were accepted. So the 2 key issues, the 2 questions that the court will actually decide are, 1, whether proving a lack of general applicability under Employment Division versus Smith, which we'll talk about in a minute, requires that the government have unfettered discretion or categorical exemptions for secular identical conduct, how wide or how narrow the discretion or the exemptions have to be before strict scrutiny is triggered. That's one question. The second question is whether Carson versus Macon, which we'll also talk about in a minute, only displaces the Smith standard when the government explicitly discriminates based on religion, because as you've probably already noticed, the Colorado law does not discriminate explicitly on the basis of religion, but on the basis of whether the school accepts supposed transgender preschoolers. So the third question that was presented is just whether Employment Division versus Smith should be overruled outright. That was not accepted by the court, so that is likely not on the table, although there are still some hopefuls who think that the first question could maybe do enough damage to Smith to actually lead to it being overturned, but I think that's probably unlikely. So let's just talk about if this is not the case that's going to just say Employment Division versus Smith is overruled, what could this case say? So I mentioned the 2 questions presented that will be discussed and decided in this case, but I want to try to maybe make them a little bit more clear because they're both kind of heady technical questions the way that they are presented by the court. So the first issue, this, like I said, is a case where the court can substantially chip away at the Employment Division versus Smith case, if not overrule it completely. So just the quick 30-second reminder, Employment Division versus Smith was a decision that severely limited the applicability of the free exercise clause by saying that if a law is neutral and generally applicable, right, it doesn't target religion, it applies to all parties, all people, all situations, secular and religious alike. If it's applicable to all, it's neutral. Then even if a law in fact interferes with free exercise, if it is neutral and generally applicable, it's not subject to strict scrutiny, and therefore there's very little free exercise protection in the face of such a law. So basically, what's going on here? What would this case do if that first question goes the way St. Mary's wants it to? So the recent precedent over the years since Smith has held that if the government has made exceptions to a law, right, for certain secular organizations or secular reasons, then the law is no longer generally applicable, right? Because there are certain exemptions or certain exceptions. It doesn't apply to all. There are carve-outs. Similarly, if the government has discretion to provide case-by-case exemptions from a law, it's also not generally applicable because the government can choose not to apply it in certain cases. So this has been an important way to chip away at Smith, to say, okay, if a law is neutral and generally applicable, then strict scrutiny doesn't apply, but there are more cases where we're going to say a law is not neutral or generally applicable, depending on the discretion involved, the exemptions given, and so on. So the question here, and Beckett's cert petition is really good in articulating this, is how much discretion does the government need to have, or how broad or on point do the exemptions have to be to a generally applicable law before the courts will say, no, this is no longer neutral and generally applicable, and we are going to apply strict scrutiny when the law violates free exercise. Beckett articulates pretty well that there's a substantial circuit split here. I'm just going to read from their petition because it will show you the distinction. So the petition says, quote, 7 courts currently consider all secular exemptions and government discretion in determining whether any would undermine the government's asserted interest. 4 courts, meanwhile, use a cramped set of potential secular comparators, looking only for identical secular exemptions and unfettered discretion, end quote. So this is an interesting point. If a law says, you know, here's the neutral law, but the court or the government agency can grant exemptions, period. That's pretty broad discretionary power. But in another law, you can imagine a hypothetical where there's a law and says, this is the case, it's neutral, it's generally applicable to all parties. In certain narrow situations, the government may be able to give an exemption if there's a bona fide occupational qualification for the employment law or something else like that. So that's basically what this comes down to. How broad does the discretion of the agency need to be, or how broad an exemption has to be given from the neutral, generally applicable law before the courts say, no, this is not actually neutral and generally applicable. Smith doesn't apply here. Strict scrutiny applies in this religious exercise case. So if this St. Mary's case is resolved favorably, it could rule that really any secular exemption to a law or any discretion by an agency makes the law not generally applicable and neutral, and that this would, I think, pretty substantially continue the trend of severely chipping away at the power of Smith. So that's one thing. The second issue at play here brings in Carson v. Macon. We've talked about this particular issue many times on the podcast, but again, brief overview. Carson v. Macon, you'll remember, was a Supreme Court case based on a Maine voucher program where if people did not live close enough to a public school, they could apply for a voucher to have their child go to a private school paid for by the government, but religious schools were not able to apply. The court said that's a free exercise violation. It's not an establishment clause problem for vouchers to pay for religious schools, and it's actually a free exercise issue if you have a generally available benefit program, in this case vouchers, right? All schools may apply unless they're religious. That's discrimination against religion explicitly, and therefore it violates the free exercise clause. That's basically what we get in Carson. So the question here is what happens when a school like St. Mary's is excluded from a generally available public benefit, in this case, that universal pre-K program, based on their religious identity, but not because they're religious, rather because they don't conform to certain ideological requirements of the program from the state. So that's what happened here. The 10th Circuit said, no, Carson doesn't apply because the universal pre-K program doesn't explicitly exclude religious schools. It excludes schools that are, in this case, not willing to take, children of various gender identities in their application and admissions process. So it's not an explicit religion discrimination, and that's why the 10th Circuit ruled unfavorably. So the problem here is that the decision from the 10th Circuit is based on the idea that Carson requires exclusion of a religious organization as religious organization, right? Because the organization is religious in order for strict scrutiny to apply. But it's important to note, as Beckett does in their brief, that's not what Carson says. Carson's rule is that excluding religious schools from a public benefit program because of their religious exercise, not their religious identity, their religious exercise is what triggers strict scrutiny. So clearly, if an organization makes the decision, like St. Mary's did here, to consider a student's supposed transgender identity in making admissions decisions, the school is doing this on the basis of its religious beliefs about sex and the human person, right? So that decision is obviously based on the organization's religious exercise. So you're excluding them because of their religious exercise, which is exactly what Carson says you can't do. The problem here is that if the court allows state laws to do what the Colorado law is doing here, to say, we're not discriminating against organizations that are religious, we're only discriminating and excluding organizations that apply their religious beliefs about sex, that gives states that are hostile to traditional religion an easy workaround to make Carson basically meaningless, right? You don't have to say religious orgs need not apply. You just say organizations that do this obviously religious thing need not apply. So in these situations, technically, yes, not all religious organizations will be excluded from a public benefit, right? There are probably religious schools who have no problem ignoring transgender issues and admitting all comers, fine. But all religious organizations here that hold certain traditional religious beliefs and actually adhere to them in the way they do admissions will be excluded from the program. So now we have a problem of the state excluding not all religions or religious organizations, but certain kinds of religious organizations, especially traditionally Christian ones. So this is problematic both because it avoids the actual point and impact of Carson, which is you can't make laws that exclude the religious organizations that you don't like from generally applicable or generally available public benefits. But it also treads into the Establishment Clause problem that was identified in Wisconsin Catholic Charities last year of governments deciding, okay, we're going to allow this benefit for religion, but only these kinds of religion, right? In the Wisconsin Catholic Charities case, it was the workers' comp exemption, but it only applied to religions or religious organizations that proselytize or that only hire members of the same or serve members of the same religion. And the Supreme Court unanimously said, you can't do that. If you're giving a religious benefit, you can't decide only this kind of religion and not that kind of religion. So that was an Establishment Clause case, not a free exercise case, but I still think we're in muddy waters here. That first of all, this is clearly just a workaround. Carson said what it said. You can't discriminate against religious organizations and let everybody else come into a program. So by extension, you certainly shouldn't be able to say, well, only these kind of religious organizations that we like, but not the ones that do the traditional religious things that we don't like. So I know that was pretty basic paraphrasing of these issues, but I think it's important to pick them apart and see what's going on here. This case is an important clarification on two levels. These are both really live issues, by the way, for religious organizations. One, how much can we chip away at Smith so that we can stop having this travesty where laws that do, in fact, discriminate against religion, but on their face don't look like they do? Can we please restore strict scrutiny and free exercise protection to these organizations? This case, if the first question goes well, could be a huge factor in limiting Smith's applicability. And the second one, this has been something we've seen constantly. Ever since Carson came down, this has been the playbook. From Maine, in the follow-up case in Maine after Carson v. Macon, to Colorado, and in several other states besides. We've had states hostile to traditional religious organizations saying, fine, if we can't exclude religious organizations, we'll just exclude organizations that don't toe the secular ideological line on LGBT issues. And if states are allowed to do that, it's going to severely limit the impact of Carson. So I'm glad we saw the St. Mary's versus Roy case accepted by the Supreme Court. Obviously, everybody would have loved to see that third question go up and just have the vehicle to try to overrule Smith altogether. But I think there are reasons to say that actually maybe this is the more prudent and possibly even the more effective way forward, instead of diving right into Smith to take on two of the most important issues affecting religious organizations in the free exercise realm. So happy to see this, and we'll obviously be following this case closely as it goes forward in the next term.
Yeah, Frank, like you explained, one of the basic questions in this case is, can you evade the First Amendment through wordplay? Like you explained, there was this claim from Colorado that they weren't discriminating based on religion per se, therefore they didn't trigger strict scrutiny under Smith, and they were able to work around Carson. The problem is, just because they didn't use the word Catholic or Christian, Colorado excluded St. Mary's and a swath of other similar organizations based on something central to their belief and central to their identity as a religious organization, right? The belief that God created us male and female in his image and likeness. It's like saying a state can ban wine consumption on Sundays without imposing a burden on Catholics, just as long as they don't say anything about Mass or about Christianity in the law itself. There are other parts of this case that are important. Frank, you did a great job laying them out. But that's something that might simplify this. Depending on how it's implemented, the Smith framework can be used to discriminate against religious organizations as long as it's done in a quiet way. This case can help change that. And just to help broaden kind of some public interest in this case, there's a few other points I want to bring up. For one, in the Colorado preschool program, there's this catch-all exemption to the typical procedures for matching a kid to a school and then giving them a voucher. This exception lets the state grant preference to a particular child/school based on the family's membership in the community. It exists to make the program, quote, inclusive of different types of communities. However, that community-based exception wasn't applied to Catholic schools or other Christian ones. With this exemption, the state is basically saying, we'll take your community into account as long as it isn't religious. Additionally, there's a shortage of schools in this program. There are more kids applying for these school vouchers than there are places available in the schools. It reminds me of that Fulton case from a few years ago where Philadelphia wouldn't license Catholic foster care agencies, despite a serious deficiency in the number of foster homes. What happens when religious institutions are singled out is that the most vulnerable people bear the consequences. Religious organizations and nonprofits are often the best equipped to serve local communities, whether that's in education, childcare, serving the poor, and states that refuse to cooperate with them are just cutting out an entire category of effective solutions to these serious social problems. And lastly, I want to close with this. I just want to note that we're talking about preschoolers in this case. I doubt that there are very many 4-year-olds that are thinking seriously and independently about their gender identity. The fact that we're talking about kids of this age identifying as gay, lesbian, non-binary, or anything else would be almost comedic because it's so unbelievable if it wasn't so deeply tragic. The sexual ideology isn't going to come into a preschooler's mind on its own. I don't know exactly how or why a little kid would start to see themselves this way, or at least say that they do, but it probably isn't because of innocent circumstances. The legal questions here are really important, but even more so is the fact that 4-year-olds are being saturated and bombarded with the lie that God put them in the wrong body, or that God made them the wrong way. So, Frank, that's some of what I'm seeing. I could get more worked up about this, but it's probably time to move on to our second update here. So now we're going to talk about a Fifth Circuit en banc decision that upheld a law requiring the 10 Commandments to be posted in Texas classrooms. Facts are pretty straightforward. Texas law requires every public school classroom to hang a poster that displays the 10 Commandments. The posters aren't used in curriculum. They aren't referenced by the teachers or anything. They're just put up in the wall. Several parents claim that the law violates both the Establishment Clause and the Free Exercise Clause. And last week, the Fifth Circuit ruled that it doesn't either. To begin, I'll just note that this case might sound familiar, Frank, like you mentioned at the outset of this episode. Earlier this year in February, the Fifth Circuit released another en banc opinion in a similar lawsuit against Louisiana's nearly identical law, but not perfectly identical. There, the court dismissed the lawsuit but didn't actually get into the merits of the case. They ruled that just based on reading the law, it's unclear whether its application would violate the First Amendment. Basically, it was unripe for a decision at this time on the merits. Here, it's a bit more interesting and exciting. The court ruled on the merits of this lawsuit against Texas's law, in part because Texas's version is a bit more clear about how the posters with the 10 Commandments would actually be displayed. There's not this question of how is this going to be implemented. They can just kind of get straight to the merits on it. So moving into the decision here, the ruling hinged on a historical understanding of religious establishment. The court said that in order to determine if Texas's law violates the Establishment Clause, we're going to look at what an establishment of religion was at the time of the ratification. And as the court explained, in the late 1700s, religious establishments gave the state control over the religious practices of citizens and imposed serious criminal and financial penalties for failing to comply with the state's established religion. States and colonies with established religions would levy taxes to support clergy. They would compel church attendance. They had a hand in controlling doctrine and worship. Disestablishment, which took place up until the 1830s, consisted of repealing these laws. Basically, essential to this notion of establishment was coercion, control of doctrine or belief. You can think of the state of affairs in England that the founders came from, where the king was the head of the church. That was kind of the background for what an establishment of religion was at the time of the First Amendment's ratification. In this case, since the Texas law is a far cry from any of these sorts of things, it does not violate the Establishment Clause. There is no coercion to religious belief. There is no control of religious doctrine. In fact, I'll just read briefly from Judge Duncan's opinion in this case, where he wrote that SB 10, that's Texas's law mandating the display of the Ten Commandments, looks nothing like a historical religious establishment. It does not tell churches or synagogues or mosques what to believe or how to worship or whom to employ as priests, rabbis, or imams. It punishes no one who rejects the Ten Commandments, no matter the reason. It levies no taxes to support any clergy. It does not co-opt churches to perform civic functions. These are the kinds of things, quote, establishments of religion did at the founding. SB 10 does none of them. So that's the basics of the opinion. Basically, at the time of the ratification of the First Amendment, the concept of an establishment of religion necessitated some degree of coercion or some degree of control in doctrine or belief. That is not at all present in this case. Therefore, this is not a violation of the Establishment Clause. There are two other crucial points that I do want to spend just a little bit of time on. And first is distinguishing this case from last year's decision in Mahmoud. So for anyone in need of a refresher, in Mahmoud v. Taylor last year, decided by the Supreme Court, a Maryland public school district required the use of books that affirmed same-sex marriage and other transgender ideologies in class curriculum. And the big dispute in Mahmoud began when the school revoked parental opt-outs. They stopped telling parents when these books would be used in class, even in grades as young as kindergarten, and refused to allow parents to take their kids out of those classes. In part because so many parents were using the opt-out that it became a strain on the school system. So last year, the Supreme Court ruled that revoking the opt-out violated the free exercise clause and sent it back down. In this case, in the Texas one, some of the parents argue that Texas's law requiring the display of the Ten Commandments poses the same threat that the court addressed in Mahmoud. The parents claim that the posters violated their right to direct their kids' religious beliefs by coercing them to venerate and be exposed to a religious text that contradicts with their own beliefs, whether they're Muslim, atheist, I think one might have been a secular humanist, or just kind of different systems that they say contradict the state's posting the Ten Commandments. However, as the Fifth Circuit rightly noted in this case, both the purpose and the manner in which the books from Mahmoud were being used are completely incomparable with the display of these posters of the Ten Commandments. In Mahmoud, these books were used as part of the class curriculum. During English classes, teachers would break out Pride Puppy or The True Story of a Boy Named Penelope or another book called Uncle Bobby's Wedding. Spoiler alert, the wedding was with another man, and would read them to kids and present them as models of morality, and this is the ideal for what we should be striving towards. Teachers were also instructed to correct any students who disagreed with the book's messages. If teachers, and this is from the curriculum's guidelines, this isn't like the parents' assertions, this is actually the district's instruction to teachers. If they were asked about same-sex unions, teachers were told to say, two men who love each other can decide to get married if they want to. If students expressed views linking sex to biology, teachers were to say, that comment is hurtful, perhaps even hateful. If students asked about transgenderism, teachers were to explain, when we're born, people make a guess about our gender and label us boy or girl based on our body parts. Sometimes they're right, and sometimes they're wrong. Similar ideas were in the books. They weren't just this, there happens to be one character who lives this lifestyle. No, the whole point of the books was to affirm a same-sex wedding or some sort of transgender belief. In Uncle Bobby's Wedding, a character that was confused about why her uncle was marrying a man was corrected. And this all came directly from the instructions given to teachers. Again, this isn't something that was conjectured by the plaintiffs. And the books were also, their purpose was to, quote, disrupt children's thinking about sexuality and gender. This is all very different from what's happening with this Texas law. In Mahmoud, the books were put into the curriculum. Teachers were told to correct students that disagreed with them. It was very coercive. These posters in the Ten Commandments case are just being passively displayed. They're not part of lessons. There's no, you should believe this, and there's no intent to enforce belief. There's nothing where this starts to touch curriculum or starts to touch coercion to belief. And I also just want to point out that the Ten Commandments are also very different substantively than these books that are being presented, because they're arguably the basis for Western morality. They have crucial religious significance, but the Ten Commandments aren't only important for religious organizations. They're throughout our country. There's the Ten Commandments in public buildings. I think they're in the Supreme Court. It's not something that's this kind of fringe religious thing. They're central to our society today. So just this concept that telling kindergartners that they're hateful for following their parents' religion is so very different from just putting up a poster of the Ten Commandments in the classroom. There's really no comparison that can be made there. And the last thing I want to talk about is how we actually got to the court's style of deciding this case. And we've talked a lot about a sour lemon in the Supreme Court's history that, though it's been rotting away for some time, wasn't actually thrown away until pretty recently. That, of course, would be Lemon v. Kurtzman. It's a 1971 case that for a long time set the test for evaluating Establishment Clause claim. And as most of our listeners probably know, Lemon was basically terrible. A big issue was that it was very vague. It led to conflicting opinions. Using Lemon, the Supreme Court decided two separate cases and one of them allowed the state to give religious schools books, but not maps. So it's the exact same thing. I don't know why that conflict would be there. And really, Lemon was just so unclear as to what actually constituted an Establishment Clause that judges could basically say whatever they wanted. A few years ago in Kennedy, again, probably familiar to most of our listeners, basically it was a case where a public school football coach would pray on field after games. The Supreme Court declared that it had long ago abandoned Lemon and its logic. In place of the Lemon test, in Kennedy, the Supreme Court said that in determining whether a challenged government activity was an unconstitutional establishment of religion, judges should interpret the Establishment Clause in a manner consistent with the founders' understanding and, quote, focus on original meaning and history. So because of those instructions in Kennedy, focus on original meaning, focus on the understanding of establishment at the ratification of the First Amendment, instead of this kind of wonky Lemon test, the judges here performed a historical analysis of what was an establishment at the time of religion, and does this look like that? And that might sound pretty straightforward, right? Lower courts are supposed to follow the Supreme Court instructions. It's actually a little bit novel, at least in this case. In fact, in the lower court here, the judge called, and as Judge Duncan called it, a creative opinion. The judge actually ruled against Texas's law, relying on a similar case called Stone v. Graham that depended entirely on Lemon. The argument in that judge's opinion was that since Lemon was abrogated, sure, the Lemon test is gone, but we didn't say anything about Stone. The issue with that logic is very obvious. Stone only existed because of Lemon. I think Stone was like 7 paragraphs long, and most of it either quoted or just explained Lemon. So it's very obvious that once Lemon was discarded, you would think that all the precedent that we got from that also would have to be revised if it depended only upon the Lemon test. Here, fortunately, the majority did see through that kind of that attempt there to bring Lemon back into jurisprudence. So we've talked a lot about Lemon on this podcast lately, really just because judges keep trying to bring it up. They keep trying to bring this test back from the dead. Anytime those efforts are blocked is worth bringing up. So Frank, as our expert on religion in the American founding, I'd love to pass it over to you and hear your thoughts.
Yeah, I love it's just the summary, the first few pages of Judge Duncan's opinion are amazing. And I know somebody quipped at our lawyers conference last week that I almost hope that the Supreme Court doesn't grant cert on this one, so we can just let Judge Duncan's opinion stand as the current precedent, at least in the Fifth Circuit. But I do think that we probably will see a SCOTUS case on the Establishment Clause, probably on these Ten Commandments cases, especially if the Eighth Circuit rules the opposite way on that case that we covered a couple weeks ago. But I'll just say this. It's not just that Lemon is a bad or a vague or a confusing test. It's that it just brings us so far from what the Establishment Clause means that I think like aggressive remedy is necessary here. I believe Judge Duncan referred to Michael McConnell's work on this, right? The 6 factors. But I think it's just worth reminding people that this is what the Establishment Clause means, right? Establishment looks something like this. Michael McConnell is an excellent religion scholar, legal scholar, and he points out like these are the factors that make for an establishment of religion, right? And you hinted at them, Joseph, when you were talking about the beginning of the opinion. But government control of church doctrine or church leadership, right? If a government is choosing ministers, is defining doctrine. If there's compulsory religious exercise, you must attend, right? Preferential financial support for one state church. Punishment for dissenting worship, use of church institutions for public functions, and limiting political office to clergy or to members of a certain denomination. These things look like establishment. Putting up the 10 Commandments on a school wall, like it's not just that Lemon is bad and Lemon could make this look like an establishment. It's not even close, right? Like if I don't even know how to describe it. It's like if you're, the definition of an establishment of religion is like 1,000-foot peak of a mountain, and like once you hit over 1,000, you're at establishment. Like the 10 Commandments on the wall is like the first little foothill, like 20 feet up in the air. It's just not even close. And I think it's worth saying that not our Establishment Clause jurisprudence has gone too far and the 10 Commandments should be fine. Like, no, there's a whole host of religious activity in the public square, publicly funded, publicly supported prayer at government functions, prayer in schools. And still, we're not even close to touching what the Establishment Clause was meant to prohibit, which was very particularly the government picking a religion, supporting it, funding it, punishing dissent from it. That's what an establishment is. That's the only thing that an establishment is. And again, we're not even close here. So I know this is a drum that I beat whenever I can, but I think this is an important opportunity. I think Judge Duncan did a really good job of not doing the kind of like, yeah, Lemon went too far, we need a better history and tradition test. He like, no, here are the factors. Michael McConnell was right. This is not even close. Get out of here. Obviously, that's a paraphrase. Judge Duncan didn't say not even close, get out of here. But that's that kind of strong pushback against this very modern and foreign take on the Establishment Clause is well needed, and it was a very heartening opinion to read the other day. And with that, we will take just a short couple of minutes here to talk about our third issue. I know we spent a long time on the first two, so we just wanted to touch on an honorable mention of this because I think it's a really important trend. So Tennessee, which was famous for being involved in the Scrimeti case last term, which said that Tennessee's government could, in fact, ban supposed transgender surgeries for minors. That was upheld by the Supreme Court as not unconstitutional. And so now Tennessee has enacted a law to allow patients to sue doctors that performed such procedures on them when they were minors. It's SB 2031 for those who want to look it up. The Tennessee governor, Bill Lee, signed it, so it is now law in Tennessee. And basically, it does what I said in the intro. Individuals who are now older than 18 can sue doctors that performed these kind of surgeries on them when they were minors. So this includes surgically removing or altering body parts and tissue, as well as prescribing puberty blockers or other hormones for the sake of supposedly enabling the person to identify with or live as an identity other than their sex. So these experimental surgeries are harming people. So now if an adult looks back and realized he was in fact harmed, now the doctors are going to be potentially liable to lawsuits in the state of Tennessee to resolve those issues. You'll probably remember we covered it on this podcast, but a couple months ago, there was this watershed moment where a woman who received a mastectomy as a child in an attempt to transition to male was the first person in the United States to successfully receive a verdict, an award, when she sued both her former psychologist and the surgeon who performed the operation. This was in New York State, I believe. It's a big step to ending these inhumane and crazy and dangerous procedures on minors. We've said this before on the podcast. It's not a new or novel thought, but laws and regulations that ban these procedures, like what we saw in Tennessee that led to Scrimeti, that's important. Obviously, these are bad things. They should be stopped by the force of the law. But practically, when doctors and hospital networks get hit in the pocketbook, when we have lawsuits, tends to be the fastest and most effective way to affect change. And you saw this immediately. I don't remember the exact stats, but there were, right after that verdict in New York, which was not a huge verdict, it was a couple $1 million, but as soon as it went through, I think people started to see the writing on the wall, and medical associations started changing their recommendations about performing these procedures on minors. Some hospital networks and university hospitals pretty quickly after that verdict announced that they would no longer be doing these things on minors. It's effective. And so as more laws like this are passed and more lawsuits are successful against the doctors, against the medical networks that have facilitated these mutilating procedures on children, I would expect to see more of these doctors and health networks back off and stop performing them altogether. So I would watch for this, watch for the individual lawsuits, watch for the laws like this in Tennessee that are creating causes of civil action for people who are harmed by these procedures. I would also look to see states expanding or opening up the statute of limitations. So children who were harmed, more than 2 or 3 or 4 years ago and are outside the statute of limitations for like medical malpractice, opening those up so that they can sue. I would expect to see more of this, and I would expect to see that this will be not the beginning of the end. I think the beginning of the end already happened, but the continuation of the downfall of this horrible experimentation on children, and thank God and good riddance.
Yeah, absolutely. Not too much to add here. Just really want to kind of continue that trend and emphasize that this is a great way to actually protect kids from these necessarily and inherently harmful procedures. A lot of the religious liberty updates we cover on this podcast center in some way around funding. That's because either stopping or increasing the money flow to organizations that carry out specific sets of beliefs, it's a very efficient way to either advance or inhibit those beliefs. Earlier this episode, we talked about the St. Mary's case, where Colorado attempted to cut off funding for Catholic preschools. If you don't want Catholic preschools spreading their message, get rid of their sources of funding. Obviously, that's a very problematic example, but that's what we're seeing. And the same logic applies here. To stop adults from taking advantage of likely mentally unstable kids and pushing them into expensive and scarring procedures, you make those procedures more costly to perform than they are beneficial. Obviously, this isn't to diminish the cultural battle that goes on. That's often the first step in these types of things. We started to see the wave of public support turn against transgender ideology in the last couple of years, especially as it impacts kids. And as that shift in public opinion starts to turn, these types of practical steps become more possible. So really just glad to see this stay law. I know similar efforts are being made across the country. Like you mentioned, Frank, I think some states are already starting to expand those statutes of limitations or pass laws like Tennessee's, and hopefully we see more of them.
Yes. And with that, we've covered a lot of ground. I think it's a good place to wrap up. So, well, as always, thank you for joining us for this episode of the Napa Legal Podcast. If you enjoy the content we're putting out, we appreciate it if you like the podcast and subscribe to our channel on YouTube, Spotify, or wherever you're listening from. And if you want to support our work financially or learn more about what we are up to at Napa Legal, you can visit our website at napalegalinstitute.org. We hope you'll join us next week as we continue to highlight and discuss the most important ongoing legal issues that affect religious freedom and the work of faith-based nonprofit organizations. We'll talk to you next week. Thank you for joining us, and God bless you all.